To the auditorium, please. We're going to get started with the next session. All right, everyone. We've talked about the military aspects of national security extensively, of course, and likewise the intelligence aspects and the political diplomatic ones. And now we're going to focus intensively on the national security and law enforcement nexus. And to do so, we're very pleased to have as our moderator for this panel, Michelle Cottle. Michelle was with us our very first year of the forum, and very pleased that you're back with us, Michelle, for our 4th anniversary. Michelle is a Washington correspondent for Newsweek and the Daily Beast, focusing mostly on politics and culture. She was previously a senior editor at the New Republic, where she covered everything from presidential campaigns to sexual politics. And prior to joining the New Republic, she was an editor of Washington Monthly. Michelle Cottle.
Thanks very much, Clark. Like all of you, I'm delighted to be here, and it is my great privilege and pleasure this morning to introduce to you this very distinguished panel. Starting down on the far end here, we have John Carlin. He is the Acting Assistant Attorney General for National Security. Before that, he was the National Security Division's Principal Deputy Assistant Attorney General. And before that, he was the Chief of Staff and Senior Counsel to FBI Director Robert Mueller. He's also served as the Director of the DOJ's Computer Hacking and Intellectual Property Program. So you're going to want to think up some really good questions along those lines for him, I'm sure. Kathleen Kiernan is the CEO of Kiernan Group Holdings. It's a global law enforcement and national security consulting firm. She's a 29-year veteran of federal law enforcement. She served as Assistant Director for the ATF's Office of Strategic Intelligence and Information. And she's also held a number of posts in both public and private sector that focused specifically on fostering collaboration between national security intelligence and law enforcement communities. So she'll have good kind of broad perspective for us. And directly to my left, David Cohen. He is the Treasury Department's Undersecretary for Terrorism and Financial Intelligence, which pretty much is what it sounds like. He heads the department's efforts to identify and disrupt the lines of financing for terrorist organizations, but also drug traffickers, weapons traffickers, and all kinds of money laundering issues you get into. So this is not his first tour at Treasury, however. He first was there in 1999 to 2001 and went back into the private sector, but he could not stay away, so he came back in 2009. So you'll be able to give us kind of a broad perspective of kind of how it's evolved over the years. Now, Kathleen, I'm going to start with you because so much of what you've focused on is exactly the nexus between the intelligence communities and law enforcement. So if you would just kind of give us the view from 30,000 feet on what progress we've made, but also kind of where our failings, where we're still falling short.
Happy to, thanks. And first, thanks for taking on a hard panel, our contentious issue at points, and thanks to Clark for hosting informed debate all the time. I'd like to take a step backwards, look back to look forward, and that is some of the giants in the business, most of whom have been in the room this week, starting with Ambassador Negroponte, who when he first published his guidance after 2001 as Director of National Intelligence, he said eternal vigilance is no longer sufficient to protect liberty. We have to establish partnerships that are different, unconventional for the intelligence community, reach out to the private sector, reach out to law enforcement, followed by folks like Charlie Allen, who said the communication between the intelligence community and law enforcement has to be more of a two-way bridge. At that at that juncture, it was interaction with the FBI for all the counterterrorism reasons, with DEA for counter-narcotics, but he said it has to be broader than that. And he established something called the Law Enforcement Working Group. And that was to bring in chiefs of police, unheard of at the time. Predecessor to John David Crisp worked with Department of Justice, cleared 10 chiefs of police at top secret. And it was an amazing feat at the time because I swear people thought satellites would fall right out of the sky and the chiefs with these clearances would run amok in the intelligence community. And these are chiefs that are still around doing good work. Predecessor to Boston, Paul Evans, Gil Kerlikowske was chief of Seattle at the time and is now our drug czar. But it opened the debate of these folks are doing a mission that is important. They're collecting information that is important to national security. General Hayden with his opening of his SHIELD initiative. Let's bring the intelligence community and thought leadership from law enforcement together and figure out where that nexus is within the bounds of law and authority and jurisdiction. And then after that, chiefs of police stepping forward, really. So 30,000 foot level, not without bumps, and I'd be remiss if I didn't talk about General Clapper, who was NGA at the time, and we took him out to a major city chiefs conference. And he got in and he was going to talk about collection. And he said, let me talk to you about collection and let me bring this down to your level. And the moment he said that, every chief in the room, and there were 56 at the time, just crossed their arms like this and looked away. And I realized that it was at that juncture a translation problem. He was talking above the treetops. Here are our systems, and here's how we collect, and this is what we do about surveillance. When in fact, he should have said, let me talk about what we do and how that may translate into your world of surveillance and collection. I left him for last in some senses because he exposed it, not exposed, he brought forward a national collection capability on geospatial analysis. And they then brought that to Boston, and with Charlie's help, integrated it into Boston and New England, and it's a foundation that they still use today. So he was willing to step forward at an early time in the debate. Now for ground truth, we talked a little bit before we started here. There's a JDLR of law enforcement, just doesn't look right, that I think has become more of a part of information sharing. So with that, I'll yield to my fellow speakers here.
Now, before we drill down into kind of the more specifics, John, I'm going to ask you a similarly broad question, which is, we've talked a lot about the evolving threat landscape. So how has your shop had to kind of change to meet this?
So in some ways, that's a simpler question for me because our shop did not exist until 2006. And the reason for the creation of the National Security Division, which is the first new litigating division at the Department of Justice in about 50 years, was to serve as the bridge between the culture and practice of law enforcement and prosecution and the intelligence community. And it was, in some ways, after the fact, seems like an obvious reform to make, but it wasn't suggested until Judge Silberman's WMD commission. It seemed like somewhat of an off-topic recommendation from that commission, but a good one. And what it did is the department combined the counterterrorism prosecutors who had reported up through one chain in the criminal division, the counter-espionage prosecutors who reported up through a different chain, and the intelligence lawyers who reported up through still a third chain. Those are the lawyers that appear in front of the Foreign Intelligence Surveillance Court, and combined those elements into one division. And part of our founding core is to participate in the interagency, the National Security Council as the justice representative, and be able to translate the language and culture of the intelligence community into the law enforcement and language of lawyers. And they're each equally mysterious to the other. And in that, it was a relatively obvious idea, again, in hindsight to do, but I think it's made just a remarkable difference in a relatively short period of time, and it's a smaller scale reform than many of the other post 9/11 reforms. And one challenge we face repeatedly is when operating inside the United States, there's a particular emphasis on if there's a disruption option or a collection option, making sure that it is done and that the tools are applied consistent with, in large part, what are tools that were designed for the criminal system. And at the end of the day, if you want to disrupt a threat, the way to disrupt a threat inside the United States will be through the criminal justice system. So while you, on the one hand, need to learn the culture and practice of the intelligence community to gain the maximum amount of intelligence you can on a threat before disrupting it, you also need to do that cognizant of the fact that at the end of the day, if you do want to take action and it's inside the United States, that you need to have preserved the ability to use some of these sources and methods in the criminal justice system. And there have been some reforms in the practice before the court to try to ease that practice of, at the one hand, protecting the rights of the defendant, and on the other hand, attempting to the maximum extent possible to protect the sources and methods that you need to continue to collect when the trial is over. We'll stop there.
All right, well, now, David, I want to bring you in here, kind of a more specific area. One significant change that we've been seeing and talking about is in the financing of these terrorist operations. I mean, in part because of the successes that Treasury and others have had in disrupting kind of the traditional ways of financing, they've gotten more creative. So would you kind of talk about, in particular, some of the new methods that you see emerging that are of concern?
Sure. And to take a quick step back also, because I think John's description of the post 9/11 sort of reorganization applies to the Treasury Department also. And what we have done at Treasury, and this came out of recommendations from the 9/11 Commission and others, is to put together an organization that combines intelligence, regulatory, policy, and to some extent law enforcement efforts to go after the financial foundations for terrorist activity and for other threats to national security. So we work closely with John's people, we work closely with the intelligence community in pursuing that. What we have had some success on, I think over the last 5 or 6 years, is pushing out of the formal financial system, the banks, much of the terrorist financing that was occurring back in 2001. We see much less use of banks to transfer funds that are destined for terrorist organizations in the Fatah, in the Middle East more generally. So what we're seeing is an increasing use of other mechanisms to transfer value. We see more use of cash couriers. We see the rise of kidnapping as a mechanism to raise money and to fund terrorist organizations. And one of the areas where we have been focusing on quite a lot recently is the use of new payment methods and new value transfer mechanisms as a potential threat to our ability to counteract financing for terrorism and financing for other illicit activity. So one area in particular that we have made some news on recently and that we're pursuing is the use of cryptocurrencies or virtual currencies, Bitcoin in particular, Liberty Reserve, another method of transferring money, where what we're trying to do is to bring into play the sort of basic regulatory structure that we have in place for the sort of formal financial system and for money service businesses, the Western Unions of the world, for securities, brokers, dealers, make sure that applies in this new world of digital currencies, virtual currencies. So, with Bitcoin and with these virtual currencies, the way we're trying to address this is to ensure that when money is put into that system or taken out of that system, so when you buy your Bitcoins or you buy your Liberty Reserve dollars, those transactions are ones that a regulated financial institution is able to track. They know who they're dealing with. They're able to identify if the transaction looks suspicious. They have record-keeping requirements and they have reporting requirements to the Treasury Department for suspicious transactions. We take that data that we receive from financial institutions, whether it's from institutions that are dealing in the Bitcoin world or in the more traditional world, we use that data, we analyze that data, and we feed that data to law enforcement to assist in law enforcement investigations.
Now, how much control do you have? Because they can operate anywhere, right? So kind of what are the tools you have with something that's getting so dispersed and it doesn't work? We were talking about the terrorist financing tracking program and how effective it's been, but this seems like it would erode that to, the effectiveness of that to a great degree.
Well, let me take those two things separately because the terrorist financing tracking program is focused on international wire transfers, essentially, the messages that go across border for the transfer of money. On the issue of the virtual currencies and how we're able to address that, there's a real challenge in that much of this activity operates obviously in cyberspace, and to the extent there is a physical location, it is often outside the United States. The regulatory system that we have in place says if you are offering services in the United States, so if some person from an IP address in the US is buying Bitcoin through an exchanger, wherever that exchanger may exist, that exchanger is obligated to register with an organization in the Treasury Department called FinCEN, the Financial Crimes Enforcement Network. They need to register as a money transmitter, and they need to ensure that they have the basic anti-money laundering program requirements to provide that information to the Treasury Department as required. Now, that's difficult. If you've got a money exchanger in Costa Rica, for instance.
Which is where Liberty was based.
Which is where Liberty Reserve was based. Our ability to sort of compel them to comply with their regulatory obligations is limited, except that we can take action essentially to cut them off from the United States. And that's what we did about 2 months ago. We used one of the authorities that we have that essentially says to US financial institutions, you can no longer do any business with Liberty Reserve. They need to have access to the United States. They need to have access to US financial institutions to operate. Because if I'm here in the US and I want to buy Liberty Reserve dollars and purchase it from an exchanger in Costa Rica, my bank or the MSB that I'm using, the money service business that I'm using, needs to be able to make a transfer of US dollars to Liberty Reserve down in Costa Rica. If we cut that off, they can no longer operate. So we took action against Liberty Reserve, cut them off from the US. At the same time, the Justice Department brought criminal charges against the people who were behind Liberty
Yeah, there's
Reserve.
been 6 or 7 indictments out of the Southern District of New York, right?
Right.
So you want to talk about how that kind of worked together as a joint effort?
So as a general matter, and this would go to the all tools approach that is part of the reason for the creation of the National Security Division. But our job is to work with the intelligence community and receive the intelligence that will describe the threat, and with our partners, including most notably the FBI, who's dual-hatted in that regard, and say, here's the threat that we're trying to disrupt. So in this case, this unregulated flow of currency. What are the best tools or levers that we can pull in order to change behavior? So in this instance, one of those tools may be, well, this meets out the elements of a criminal offense, so we can bring criminal charges based on the information. But simultaneously, particularly National Security Division, we shouldn't just be focused on the prosecution as the measure of success. We should be working with groups like Treasury to see if there are civil measures or sanctions that can be imposed that might even be more effective in a particular case at dissuading others from conducting that activity. This is a good example, I think, of the joint approach.
Now, as the terrorist groups move toward criminality to fund a lot of this stuff, I assume this opens up opportunities for coordination with like different law enforcements, both here and abroad, that help you kind of get at them a different way. I mean, is that accurate?
Yeah, no, that's accurate, and it serves multiple purposes. So many of these groups now engage in what we'll call traditional criminal activity in order to fund their terrorist activities. So whether that's kidnapping for ransom, as David mentioned, or money laundering, counterfeiting sales, including credit card fraud. The ability to look from the perspective of who's the threat actor, who's top on the matrix that's been set forth by the DNI in terms of our priorities to disrupt. And let's say there's a group that you want to target like Hezbollah. From our perspective, are you looking just to bring terrorism charges against Hezbollah or material support for terrorism? No, you want to take whatever actions you can to make it more difficult for that group to plan, plot, and execute its terrorist activities. And the prosecuting and bringing prosecutions for traditional criminal activity serves both the goal of making it harder for them to raise the funds that they need, and also it reveals a side of the group, because some of these groups will also message or market themselves as legitimate political actors. It also helps message that they are not, and in terms of discussions with partners, while they might not agree at labeling it terrorist, or their legal regimes at this point may not have statutes that effectively address terrorism, and that's something we've been working on to try to help develop similar codes in other countries. The only available tool in that country might be the smuggling charge or the traditional criminal.
Yeah, can I just to pick up on what John's talking about with Hezbollah in particular is a great example of how we have gone after terrorist activity in a very dangerous terrorist organization through a more traditional law enforcement lens. What we've done at the Treasury and worked with law enforcement, the DEA in particular, is looked at the massive money laundering that is going on in the Lebanese financial system. Give a very simple description of it. Used cars are sold in West Africa. Used cars that come from the United States, sold in West Africa. The money from those used cars is then used to fund drug activity all across Europe and to pay the drug dealers across Europe. It then gets laundered in Lebanon and the money coming back to the US. What we've done is used tools that we have, again, to cut off financial institutions that pose a threat to the US financial system. We've used those tools to address a bank in Lebanon called the Lebanese Canadian Bank, to address a couple of money exchangers, so these entities that take in cash and then deliver it up to banks, which then transfer the money back to the US. We've identified them under our regulatory tools to protect the US and focusing on the money laundering aspect, but also making clear as we're doing that the money laundering activity is financing Hezbollah, and that Hezbollah is deriving benefit from this activity. So we're not going after Hezbollah purely as a terrorist organization that the Lebanese regulators need to deal with. We're focusing on it as a criminal enterprise and an enterprise that's involved in sort of traditional money laundering activity, which makes our bilateral discussions with the Lebanese authorities much easier, because we can talk to them about it in terms of criminality.
Now, I want to bring it back to the domestic stage for a little while. So, Kathleen, I'd like you to talk about the rising threat of homegrown extremists that we've been talking about. This seems like it shifts more of the burden for data collection onto law enforcement. Mm-hmm. And so I want your thoughts on kind of what this will mean, what they will need to be doing to prepare to handle this, and kind of what steps you've seen that have already been taken.
Sure. To David's point, there's an old adage in the community that every criminal is not a terrorist, but every terrorist is a criminal. And although the end result is different, the motivation and the tactics to get to that end are very analogous. They need money, they need safe haven, they need a construct of a network, they need weapons, they need false identification, even though, again, the end result may be different. So it seems axiomatic that we would look at the tactics that law enforcement has used traditionally to unravel these networks. Let me give you a couple of examples. Famous cases, really. It's that JDLR we talked about earlier in law enforcement. They're positioned to look at patterns of behavior, and it really is about anomalous behavior. It's looking at migration patterns, and I don't mean migration in terms of ethnicity or immigrant populations, although sometimes those come into play. But the migration in can I speak this morning? Assimilation of criminality, of patterns of behavior for drug use or gun violence or accumulation of explosives, those kinds of things that are migratory. And they show tipping points within a society. And if you can study that behavior and understand the anomalies within it, it will give you indicators of networks and be able to better focus resources on disabling those networks.
Now, one of your hats is that you've been intimately involved with counterterrorism training techniques for law enforcement. What have you seen in there in terms of like the biggest cultural challenges or kind of the things that need to be focused on?
I think it's back to the translation piece, understanding what law enforcement does for a living within the bounds of authority in terms of collection, what they collect and what they do with that information, and exploiting it beyond just the initial case into the networks. And taking that earned experience or street craft of law enforcement and translating that into the trade craft of a intelligence collection or a senior level counterterrorism strategy.
Now, as this goes forward, kind of what does the civil liberties issue, how does this come into play? Kind of what sensitivities are there? I mean, because in these cases we're talking about American citizens or, law enforcement that's operating under our rules of law.
Ever-present concern. Law enforcement is well-schooled in issues. They always come to the press in terms of immigration and not having regular law enforcement officers engage in immigrant interrogations and those kinds of things. But they're well-schooled, they know the rules. The tension really is on U.S. persons and what information can be shared with whom under what constraints.
All right, John, over to you on kind of this similar issue, which is, it's a hot topic these days, the eternal tension between privacy and security. And one of the missions for national security lawyers is to try and find that right balance. So you want to give you guys a grade on kind of how that's going and what still needs to be done?
Yeah, so I will forthrightly avoid that question on grading, but I think it's very, there are the larger issues where you develop a framework and you try to develop a framework where within that framework you can wrestle with the balance between the need to protect our national security and civil rights and civil liberties. And then underneath the framework, when you wrestle with a particular matter and try to solve it, I think part of our jobs is to approach it with a particular problem in mind, and how do you solve this problem given our legal framework, and it becomes very tactical and fact-specific. And what you need are lawyers who are fluent in both the rules and regulations that govern the intelligence community and in the variety of civil and criminal tools that can be applied inside the United States. And so that's where an issue like where we discussed about earlier with Hezbollah comes into play, and you look at what's the range of their conduct, what are we trying to disrupt, and which parts of their conduct are vulnerable to already existing tools because they violate a particular rule or regulation or part of the criminal code. And we've become more familiar and practiced in that approach. Some of it may sound common sense now, but really was a different way of thinking about the problem and not analyzing it, at least on the law enforcement side, as I have a particular set of facts in front of me. Does this or does this not fit under the criminal code? And if it does, let's go. Versus what has the intelligence community identified as the problem that we're trying to solve? And now when I try to tackle that problem, where is it vulnerable to an existing legal or regulatory regime? And so it's a different approach.
You go ahead.
Picking up on what you asked me earlier about the terrorist financing tracking program, which I think is a good example of how we address this balance between privacy and obtaining data so that we can pursue our law enforcement and financial disruption mission. The terrorist financing tracking program is something that is now subject to an elaborate agreement that was worked out with the European Union a few years ago. It had operated for several years without there being an explicit agreement with the EU. The the program was revealed in a New York Times story in June 2006. That then led to negotiations with the EU, where now in a collaboration with the EU, with the European Commission, something that the European Parliament has agreed to, we on a monthly basis get bulk data from the SWIFT transactions, these cross-border financial transactions. When we get this data, the request has to be narrowly tailored, both in geography and in the type of information we're seeking. It has to be approved by a European authority, the Europol, which is their sort of central police force there. We take this data in, we keep it in a secure environment. We're only allowed to search it for counterterrorism purposes. There are real-time people who review these the searches in real time and can stop a search if it's not for a counterterrorism purpose. And we share that information both with the EU and with law enforcement domestically to pursue counterterrorism investigations. So there's very elaborate protection for the data that we're getting from the European Union. Now, that works in this circumstance where we are working collaboratively with the EU to get this data. There are other circumstances where data is obtained by the intelligence community not through an agreement, but through other means. And I know one of the issues that's very much in play now is whether there ought to be a similar sort of elaborate system put in place when the intelligence community obtains data unilaterally, not through an agreement. I'll leave that for others to discuss, but the focus in the TFTP program on ensuring that the privacy rights of European citizens and US citizens also is protected is something that we have been very scrupulous in pursuing.
Yeah, because I know you're going to be very disappointed if there's not at least one Snowden-related question. How much blowback or how concerned are you about there being a kind of ripple effect and this impacting this program?
Look, I think there's reason to be concerned. This program has been, the TFTP program has been very valuable. It has helped law enforcement and the intelligence community disrupt activity in the United States. We share, as I said, with our partners around the world. It has helped to disrupt plots in Europe and elsewhere. And we continue to derive benefit from this program. So it's an important program for us to be able to continue to pursue. There is obviously some concern being expressed by our partners in Europe about what has been revealed from Mr. Snowden. I think it's important to understand the difference between TFTP, which is a program that, to say, has these elaborate protections that are built in, because of the nature of the program. It is a collaborative program to pursue counterterrorism investigations and to look at any other type of intelligence collection in a different lens.
Now, John, this obviously gets more ticklish, this balancing act, when you're dealing with American companies and things like this. So we were talking, you were talking about how you have to look at these things in the specifics, but what about Microsoft's pending request that they be allowed to be more transparent with how they're handling security requests? So how does something like that get balanced, the pros and cons and balance in the public relations? There's a whole bunch of pieces that go into that, and how do those decisions kind of get played out?
So I think looking the goal has to be to try to be as transparent as you possibly can, while at the same time talking closely with the intelligence community and making sure that we protect the sources and methods in such a way that the conversation itself doesn't make the collection activity impossible to conduct in the future, or substantially more difficult to conduct in the future. And often when you wrestle with it in the context of a specific request or program, you can find a way to make that accommodation. occasionally there'll be instances where it really is just very difficult to discuss it publicly. I'm going to take a step back, and this will be something I think that's under discussion now, but there was a concrete rationale and well thought out approach back in '78 in response to the abuses that were identified in the church report about how do we, as a society that places a premium on transparency and accountability, accommodate the fact that there are clearly activities that need to be kept secret in order for them to be effective, that are very important in protecting our safety. And what they came up with is, and we're looking at this now, I think it's a regime really unique in the world. It involves, and it's very American, it involves all three branches of government, which is often the American constitutional approach to solving a problem. And it involved statutes that require vigorous oversight by the executive branch. It set up a foreign intelligence surveillance court that, while the matters that they hear are necessarily, given the problem that they're trying to solve, secret in terms of what appears before the court, the existence of the court, the basis for the court, and the judges on the court are not a secret. And these are the same judges, as a prosecutor that I appeared before in an Article 3 setting, and they continue to keep their criminal and civil dockets. Their names are public, and after they serve a term of years, they go back to their full-time duties. And actually, while they're on the court, they continue to hear matters. And having personally appeared before some of those judges both in the local Superior Court in the District of Columbia, the federal court, and now seeing them in the FISC, I can assure you, and because it is public, you can read some of the opinions for yourself. They are some of the judges that are renowned for holding the government to a very high standard, as they should. And then you also created the construct of the intelligence committees, who were designed to hear this information, all of the information, in a classified setting, and to make sure that they have available to them all of the significant opinions of the Foreign Intelligence Surveillance Court. And they bear special responsibility, those committees, under the structure that we set up in '78, where because they are privileged to hear in detail what's going on with the intelligence community, that their opinions carry a special weight, and when they review then statutes, et cetera, or conduct oversight, that they're empowered to see the full range of activities. That three-pronged system, I think, was not maybe that familiar to the American people, though it's public, and it just hasn't been discussed, thought about, and assessed for a period of time. And right now it's undergoing a period of scrutiny, and it came out, I think, not in a full and thoughtful way, which is the nature of fast-moving news cycles. So I think some of that context was lost, where ideally you'd have a discussion, okay, this is the structure that we put in place. Here are certain activities that were approved and lawfully authorized under it, and is it a structural problem? Do we just not like the result that occurred? But I do think you can have a fair amount of pride as well that there was a thoughtful approach, and they designed the system specifically to see whether you could balance the needs for secrecy and classified information with that need for transparency. And while it may need tweaks, I don't think there are many other countries in the world that have that kind of rigorous judicial, executive, and legislative oversight of their intelligence activities.
All right, Kathleen, you were talking about surveillance from a slightly different perspective, specifically Boston. You were pointing out the benefits of cameras and kind of passive surveillance, but also, with the heightened concerns about a surveillance state and all this sort of thing, would there be a pushback on that? And kind of, what's your sense of where that's going and what the problems could be?
Let's talk about Boston for a moment. I think it exposed the very best of law enforcement in some senses, that no matter what the issue is or the color or the shape of your badge, everybody responds to the scene and does the job that they've been very well trained to do. They did some crowdsourcing of data, which I thought was interesting. It had a downside of that where people took on almost a vigilanteism in terms of identifying the bad guys. But in a good sense, the public responded in such large volume and actually crashed an FBI server the first couple of days. But that's a good sign. It's a good sign that people are involved, they're passionate about their city, whatever that city is, and they want to help. So I thought that was a very good sign. Downside of some of the things that happened in Boston, it did expose still the divide from federal, state, and local, and what information can be shared with whom when. End result, still positive, but I think it just exposed the friction. We've come, no pun intended, it's been a marathon. We've come a long way in terms of the National Counterterrorism Center and rotational assignments for state and local police officers, outreach by Department of Homeland Security, bringing state and local folks into the national level. But again, still a tension there in terms of, is it a matter of trust? Is it a matter of we can't keep the information or can't utilize it? But again, it's come a long way. I think people are used to being under surveillance in most senses. When you really think about it, I read a story that said people are photographed 200 times a day at an ATM machine, at a gas station, at any public building, at airports. And it's just a fact of life. New York has done a very good job emulating the Ring of Steel. Chicago has done that as well. Boston has a pretty good system. I'm sure it will be enhanced.
Now, you disagreed with the suggestion put forward, though, by a panelist that Boston wouldn't have happened in New York.
General Hayden made that comment, saying that it was perhaps preventable but not inevitable. And it's interesting. If you'd ask Ed Davis or Tim Alvin from the state police whether it was preventable, I think you'd get into, it would force the discussion of what information was available to whom when. Mm-hmm. But I think if you had the discussion with Ray Kelly, he would say that the sense of vigilance in New York and the technology that's available to the city of New York perhaps is more enhanced.
Now, there was also some talk about whether counterterrorism needs to come down a notch or two on our list of priorities. And you seem to kind of be sympathetic to that to some degree. Is that?
Well, when you think about, I think it was Phil Mudd talked about synthetic drugs and active shooters and other kinds of crimes. You think about childhood obesity, but 18 arrests on terrorism since 2001, and the last stats I looked at in 2011, although 2012 stats are just starting to come out, there is a vehicle stolen every 42 seconds, a robbery every minute and a half, a rape every 6.5, and a murder every 36 minutes. So in a sense, there are bigger and broader problems domestically. Now the other side of that is law enforcement investigating those types of crimes are positioned to look again at behavioral anomalies and look at clusters of behavior that may in fact be pre-incident indicators to network and terrorist events.
Yeah, I mean, there's obviously still a fissure or an information gap, but has law enforcement kind of absorbed enough of the counter-terror mission that a lot of what they're doing is now so intertwined that they kind of, when they're investigating one, a lot of the times it's investigating the other as well?
I think so. 10 or 12 years ago, even the word requirement was a new word to law enforcement. They don't think in terms of requirement. They think in terms of serving and protecting their communities and their nation writ large. They don't think in terms of intelligence community requirements. The change with a new terrorism requirement to state and local meant a whole new series of applying for grants and getting other capabilities, and then, in a sense, getting a nerd to having those capabilities be ever present. Do I think that they completely understand the terrorism mission? I think they do. I don't think they see a big difference between criminality and terrorism. They're looking, again, for those behavioral anomalies.
Coming at it from a slightly different angle, I mean, do you think we are or should be moving back toward a more law enforcement-based approach to counterterrorism?
The see it, say it, or see something, do something, it's what law enforcement does, and I think there's some valuable lessons to learn there, and I think there is some information that is collected in the regular course of policing that is illustrative and actually can illuminate networks. That's what policing does. It goes after networks, organized criminal networks, gang networks, drug trafficking networks.
No, I wanted to, oh, you.
Yeah, can I just sort of on the, ought we be relaxing a little bit on counterterrorism? I think the reality is, in the last 10 years, we have gotten as a country much, much better, both in what we do domestically and what we've been able to do internationally to reduce the threat from terrorism. By no means does that mean we ought to forget about the mission. There's still a lot to be done. We need to stay, on that mission. But there are also other significant national security threats that we need to ensure that we are spending enough time focused on. And so, leaving aside sort of the domestic issues and Phil Mudd's, childhood obesity and synthetic drugs issue, but looking, internationally and looking at what we're doing as the Treasury Department in trying to disrupt financial support networks, we still spend a good deal of time looking at the financial support for terrorist activity, but we have, in the last several years, expanded our focus into transnational criminal organizations. We have a new sanctions program that is designed to try and undermine the financial support for those sorts of organizations that are involved in human trafficking, who are involved in the drug trade, and who, there's the risk will, have a merger down the road with terrorist organizations. So we're focused on those sorts of issues. We're, continuing to pursue narcotics as a significant threat. One of the very active programs that we have goes after drug kingpins. We're continuing to work on those fronts. And obviously we do a lot of work on other sort of broader national security threats, whether it's the Iranian nuclear program or what's happening in Syria or North Korea. So I think that much of what this conference focuses on, what we've been talking about, is counterterrorism and what we can do to combat terrorism. But I think if we are thinking about the national security threats and how law enforcement can play a role in advancing our national security interests, we need to take a broader perspective and not just focus just on counterterrorism.
Now, as far as tools for a lot of these new things, and this also plays in with the terrorism aspect of it, but you were talking about international kidnapping and how this is a focus of treasuries. But kind of at what points can you get involved, and kind of what are the pressure points you have, especially because in a lot of cases you're dealing with foreign governments and foreign citizens, because as we've talked about, the U.S. its policy is not to pay out ransoms, but that is not the case a lot of places, and so it then gets into tricky territory and you're dealing with local law enforcement elsewhere. So kind of what are your tools and how do you approach something like that, which is kind of a different sort of threat?
Well, in large measure, we approach that through diplomacy, through working with counterpart governments around the world. And in the kidnapping for ransom situation in particular, the U.S. government has long had the policy that it will not pay ransoms to free a hostage. The UK has the same policy. It is a policy that, over the long term, we think is protective of U.S. citizens. If the folks out there who are taking hostages know that they're not going to get a big payout, a big ransom payment from the U.S. government, it's less likely that our citizens will be taken hostage, and I think the evidence bears that out. So one of the things that we have been working on with counterparts around the world is to try and get other governments to adopt a similar approach, that it will protect their citizens better. And I think we're at the G8 conference, the summit just a few weeks ago in Ireland. The leaders of the G8, one of the outcomes that was in the communique was an endorsement by all the G8 nations of a no ransoms approach to kidnapping. That's an important way to undermine the strength of terrorist organizations in particular that, whether it's in North Africa or in Yemen, fund themselves increasingly through ransoms.
All right. And with that, I'm actually going to open it up to your questions because I know you've got to have several. The gentleman right here up front.
Hi, David Trulio from Raytheon. Question for David. Granted that these are budget-constrained times, I'm curious how you look at your technology capabilities and what you need, what your needs are, what you wish you had, maybe better analytics. Just, I'd invite you to comment on that. Thank you.
Yeah, I mean, we are. We have an Intel shop in the Treasury Department. We're the smallest, but I think the most interesting Intel shop in the entire intelligence community. We have analysts who have, access to all of the intel that's collected by those who are out there collecting. They have, good tools. Do they have, everything that would be useful? I think we're constantly looking for enhancements to our technology. On the domestic side and on the sort of the anti-money laundering regulatory side, one of my units is, I mentioned, the Financial Crimes Enforcement Network, which is the entity that receives reports from domestic financial institutions of cash transactions, the suspicious activity reports, and what have you. They have just gone through a very significant upgrade in their technology, which will enhance their ability to do analytics on the data that they're collecting, and also, very importantly, share and make that data more readily available to our partners in law enforcement, so that the FBI, IRS, Secret Service, whomever, DEA, can use the BSA data, the Bank Secrecy Act data that we collect, to sort of round out their investigations and develop leads. So much of what we do is very data-driven. Much of the value the Treasury Department brings to our partners is the data that we have and the analytics that we apply, and it's always a challenge to keep that stuff up to snuff.
Michelle, if I may comment on that, I think it really is two things. One, technology, and one, the human being. It's continuing to tune that human analyst and then giving that person great analytical tool suites.
Yeah. Way in the back.
Hey, thank you. Ryan Leslie with The New Yorker. I have a question for John in your capacity as the head of the National Security Division at the Department of Justice. One of the records that the Justice Department has set in the Obama era, of course, is its record use of the Espionage Act of 1917. With the Snowden charge, it will be the 8th whistleblower/leaker, depending on your definition, who will be charged under this act. I wonder first if you could comment on the Justice Department's use of that act, why it has increased so much in the Obama years. And then secondly, last week, the Department of Justice put out some new guidelines concerning its investigations that deal with the media. One of those guidelines suggested that in some cases, something short of the use of the Espionage Act should be used when there's classified information is leaked. Just want to ask you, did you interpret those guidelines as a mandate to move away from the use of the Espionage Act? So two questions there. What explains the increase in the Obama administration's use of that act, and do the new guidelines suggest a mandate away from it? Thanks.
Sure. Let me start with the second first, or tie the two together. Fundamentally, so there's been and there continues to be a debate about what the right balance is, but obviously there are members of the intelligence community who sign and swear that they will not pass information, they will not transfer information that would damage the national security or cause exceptionally grave damage to the national security. And I think there's some consensus that there's a category of information where it really will be extraordinarily damaging for that information to be made public, and we need to figure out a way to deter people from doing it. And then it becomes similar to our discussion about the approach to terrorism. What's the most effective way to stop that from happening? I know it's been the flavor of the discussion throughout this conference. I was interested a little bit earlier this morning in the discussion with the media panelists, and I was thinking one other thought. I think it was Mr. McLaughlin who raised some of these issues, but in part it goes to the discussion we were talking about here, that for one of the transformations that had to be made as we move from what was called the law enforcement model to the intelligence model, and changed up culture, at least for a group like FBI, you're used to writing your reports in such a way where you know it's going to be litigated, and you're trained, it's not to necessarily hide information in those reports, but before you put anything down on paper, you know that it's going to be subject to discovery, and you had better be very, very careful in the way that you phrase it, because a sloppy phrase in a write-up of an interview or an internal report assessing evidence then can have enormous and sometimes consequential impact on your ability to ever bring a criminal case. And so there was a culture in terms of writing those reports. And one of the changes in post 9/11 was building this analytic side so that you could take that information and make assessments and give broader types of analysis that could feed into the intelligence community. Well, in some ways it's similar to this prospect of mass leaks, because there's the side of it that's sources and methods, and then there's also the side, and this was the trust that PJ was talking about earlier, where in order to have a free and candid, and for lawyers we're used to that in terms of like the privilege, that certain things are privileged in order to, because we as a society want certain people to have a free and candid discussion and exchange of ideas, and they wouldn't frame it. They would be much more careful in their phrasing, and the communications would be slower if they had to think through how to phrase everything in terms of public debate. And similarly, when you talk to a counterpart or an ambassador or a foreign intel service, they have a expectation that when you write up what they say, that it's not going to be public, or they too would be much more careful and parsed in their phrasing. And that type of candid, real-time, fast conversation, I mean, I don't think you can emphasize enough how important that is in disrupting particular threats. And we need to make sure that whatever we do, we continue to have a system that allows for that. So, a long introduction to, I think, dating years back, not just as a result of the recent guidelines, there was a thought that there are very few, and even with recent numbers, there are very few successful prosecutions for leaks of classified information. And there are a variety of reasons for that, not least among them because of the special protections and relationship that you have, because you want a robust and free press. And so steps that we would take in any other case, obvious investigative steps at the front end, you don't take in those cases, which makes it very hard ultimately to find sufficient information to bring the charge. So if even if the number is 6 or 7, that's still a very, very small number compared to the amount of information that gets out there. So what else can you do in the system? And so there, I think, for a while now, there's been a thought, well, is there some way administratively or in terms of the rules and procedures and training inside the intelligence community and agencies that we can better address what the core of the issue is, which is that decision by an individual to pass information that they should not be passing, that it's illegal to pass.
All right, we probably have time for one more. The gentleman right here.
This was a question I think was supposed to be addressed by General Alexander's presentation, which got sidelined by the Snowden affair response. So my question has to do with just how effective are cyber defenses. Perhaps John Carlin, with his background, would have some light on that. What's disturbing is that it's reported that Lockheed's F-35 stealth aircraft program was penetrated and compromised at a cost of tens of billions of dollars and delay of the program for almost a year. It's very disturbing if that, with all the resources of the Pentagon, that couldn't be stopped. I was wondering if the financial institutions' defenses, cyber defenses, have fared any better. I would hope so. And one concern is that it's been reported that the national electrical power grid system is unprotected and is very vulnerable to attack and shutdown. I don't know if you have any insights to how effective defenses are.
I'll say that that's an excellent question, at least in terms of our top priority in addressing an emerging threat. It's addressing the national security cyber threat. And by that, in terms of how we address as National Security Division, would be focusing on state actors and then non-state actors that would do an attack for a terrorist or political purpose as a terrorist act. And we are addressing that issue as quickly as we can, but for our division in particular, we had not made some of the same transformational steps that we had made to address the counterterrorism threat, and are just starting to try to apply some of the lessons we've learned in taking the threat-based approach to counterterrorism to national security cyber. So, for instance, we at the U.S. Attorney's Office level, and there are 94 U.S. Attorney's offices throughout the country, we had prosecutors who are trained in prosecuting computer hacking offenses and are very good at the technology involved and the relevant statutes in terms of prosecuting those cases. And then on the other side of the house, we had our terrorism prosecutors, which are called ATACs, and they were very used to trying to protect sensitive sources and methods and still be able to bring a criminal prosecution, and also we're used to working with the FBI to, even if it's a case that may stay purely in the intelligence lane, give them, here's the full set of tools, as we were discussing before, that you could use to legally obtain information that you need to gather additional intelligence on this threat. We didn't have or focus on the seam between those two, which is someone who's both versed on the technical side and the computer hacking side, and someone who thinks about the national security side and is used to dealing with the intelligence community. Similarly, at Main Justice, we didn't prioritize it within the division, where we had an operational section that really focused on, okay, what are the tools in our toolbox here? We're used to sanction regimes and a wide set of civil tools when we're dealing with terrorism. Have we really thought that through each time we get intelligence indicating a particular actor is stealing economic information for their state's benefit? So just in the last year and a half or so, we now created a network so that each U.S. Attorney's Office has at least one, and many of them have developed units, prosecutors who we brought back to train. About half of them we had to train on, here's how to do sensitive sources and methods, here's how FISA works, here are the players in the intelligence community. And for the other side of the house, here's a computer, here's an IP address, here's how it works, and then going up to the 200 or 300 level and teaching folks. And similarly, we're just starting in earnest the conversations with folks like David and others about what are the tools other than, we need to think about criminal prosecution as one of the tools. We haven't really used it to address a cyber attack by a nation state actor, but also what are the other range, or how would a civil sanctions regime apply? Are there information you're getting in the regulatory sphere that would be helpful to disrupt a cyber attack that isn't passing over the transom? And the FBI simultaneously, I think, was approaching many of these cases as intelligence collection platforms, but they weren't having the conversations with prosecutors or lawyers about disruption options, and they've changed that practice now. In part, they didn't have a counterpart in the field to do it, and now they do because of the change in the U.S. Attorney's offices. So we're in the midst of that transformation, and I don't think we've addressed the threat yet, although we continue to move to do so as fast as we can, but we need to continue there to catch up to the extent of the threat.
Okay, and on that note, I'm afraid I'm going to have to free our panelists for lunch, but I want you to feel free to corner them and grill them heavily while you're having your own lunch. Thank you so much.